Well, good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, December 15th, 2021. The time's 9:30 a.m. With us today are Commissioners Emily Lindley and joining us virtually, Commissioner Bobby Janeka. Good morning, Commissioner.
Morning.
We have audio, good. We're also joined by our General Counsel, Mary Smith. I'm John Neerman. And today's meeting, as you can tell already, is a hybrid meeting. Most of the participants will be joining us virtually, so I'd like to remind folks to please keep your microphones muted when you're not speaking. And if you're here only to listen, you can do so online, and the link is available on our agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to speak to, and we will do our best to accommodate that request. For those making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. And again, try to remember to turn your microphone back on before you begin speaking. And with that, I'd like to thank everyone for being present. And Ms. Smith, I'll ask you to please call the first. Well, I think we were going to maybe take things out of order. We had Representative Thompson who wanted to speak to item 1 today. And if she's on the line, we'll take it in order. Ms. Smith, if not, we'll take up item 2.
My understanding is she's not on the line yet. So would you like to go to 2?
Let's go to 2.
Item number 2 is the application by United Ready Mix LLC for issuance of air quality standard permit for concrete batch plant registration, number 16145. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
All right, for the benefit of those who are unfamiliar with our process, we have a 2-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming at least one requester has met those requirements, we then consider which issues are appropriate to refer to hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. And this item is for a concrete batch plant. There's an additional requirement for concrete batch plants under the Texas Clean Air Act. Only those persons actually residing within 440 yards of the proposed plant may request a hearing as an affected person. So on this item, we have 2 requesters, Ms. Picard and Ms. Hamel. Both reside within 440 yards of the proposed concrete batch plant. This item turns on a procedural issue, and that is whether the requesters articulated personal concerns both in their comments and in a timely hearing request. And both did indeed articulate personal concerns in their comments. However, Ms. Picard's hearing request is simply a short statement without any reference to her personal concerns about the proposed plant. And because she fails to meet that procedural requirement, we're required to deny her request. Ms. Hamel's hearing request is a little bit of a closer call. She states, and this is a quote from her hearing request, "I'm sorry I forgot to ask for a hearing request with my previous message," that is referring to her comments. "I'm asking for a hearing." And I think, colleagues, that we can view this a couple of different ways. Here's how I view it. While Ms. Hamel did not restate her personal concerns in her hearing request, her hearing request reads to me as an amendment to her comments. It's a correction of her comments, which were intended to serve both as comments and as she states, as a hearing request. So procedural requirements can be really unforgiving, especially for pro se requesters, and so I think it's better to give Ms. Hamel the benefit of the doubt on this one. So I would grant her request and find her to be affected. Commissioner Lindley, what do you think?
I'm in agreement. I'd be comfortable granting Ms. Heimel's
Commissioner
hearing request. Sorry.
Okay. Commissioner Janeka.
I'm arriving in the same place as well. Very comfortable proceeding with Ms. Hamel as an affected person.
All right. Turning to the issues, I believe Ms. Hamel has preserved two issues. First, whether the permit is protective of the requester and her family, and two, whether the permit is protective against dust emissions generated from the proposed plant, including nuisance dust emissions. So I would refer those issues to SOA. I would also include an ADR referral on this one.
I completely agree.
I see nodding from Commissioner Janeka. I think I'm ready to entertain a motion on this one.
I'll attempt one. I will move that we grant the hearing request of Melinda Heimel, deny the remaining hearing requests, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, that we refer the matter to SOA for a contested case hearing on the following issues. One, whether the permit is protective of the health of the requester and her family, and two, whether the permit is protective against dust emissions generated from the proposed plant, including nuisance dust emissions, and that we specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, has Representative Thompson been able to join us yet?
I do not believe so.
Okay. Well, why don't we keep rolling and we'll come back to item one then. If you'll call the next items.
The commission will be taking up items 3 and 4 together. They are the consideration of the appeal filed by Ector County Appraisal District regarding the positive use determinations issued by the executive director on application numbers 23951 and 23954. Each party will have 5 minutes for oral argument and will present in the following order: Ector County Appraisal District, then GCC Permian, the ED, and then OPIC. The appraisal district may save time for a rebuttal as it bears the burden of proof as the applicant, as the appellant.
Thank you, Ms. Smith. And do we have someone from the appraisal district on the line?
We do not, Chairman.
Okay. Is there someone with the applicant on the line?
Well, I don't know.
There's a man named Mark trying to get on the line right now. That is representing him.
I'm here.
Oh, great.
Good morning, sir. You want to state your name and your affiliation, and then the floor is yours.
Sure. Thank you very much. First, my name is Mark Vizetta, and I am acting here as a representative for GCC Permian with regards to this hearing for the two applications, 23951 and 23954.
Thank you, sir. Were there any comments that you wanted to make about it, or should we just proceed just with the benefit of the briefing that you all did?
Sure. Okay, my comments are application 23951 concerns the raw material storage building. The raw material storage building was constructed to store raw materials and to reduce particulate matter releases related to storage and handling. The rule cited in the application is 30 Texas Administrative Code 111-111A8A, which limits visible emissions. The raw material storage building was constructed to reduce visible particulate emissions generated by the storage and handling of raw materials. The environmental benefit, as described in the application, is the reduction of particulate matter releases related to storage and handling of raw materials. Tier 1 table item A6 includes enclosures used for particulate suppression. The building is not used as production equipment and does not produce a marketable product. Since average annual rainfall in Ector County is less than 15 inches, the building was not constructed to prevent rainwater from contacting the raw materials. Water rainfall is not the issue here, but more so the wind that facilitates the disbursement and release of the particulate matter. That's for application 23951. Now for 23954, the concerns regarding a project to replace the GV87 Kiln 1 exhaust stack, the rule cited in the application is 30 Texas Administrative Code 111-151A. This rule states that no person may cause, suffer, allow, or permit emissions of particulate matter from any source to exceed the allowable rates. The original stack was constructed to conform to this rule, as is the replacement stack, which is what this is for. Application number 8640, which was issued a 100% positive use determination, Tier 1A1 on May 18, 2005, was for the repairs on the dust collection systems on this baghouse. This baghouse's purpose solely is to remove particulate matter from exhaust gas streams from the kiln. The description of Tier 1 table item A184 is the incremental cost difference between the stack height required for production purposes and the stack height required for pollution control purposes. GCC Permian completed the appropriate section of the application for incremental cost difference. The stack does not produce a marketable product. Conclusion, the raw material storage building and the GV87 Kiln 1 exhaust stack are listed on the Tier 1 table. Tier 1 applications requesting 100% positive use determinations were filed. Appropriate adopted environmental rules were cited in the application. Explanations of the appropriateness of the rules were provided. The environmental benefits of the property were described. The incremental cost difference for the application was completed for application number 23954. An appropriate explanation was provided. Neither item is used to produce a marketable product or for a purpose other than pollution control. The applications received 100% positive use determinations. Receiving a property tax exemption for pollution control property is a two-step process. The TCQ is responsible for determining if the property is used as pollution control property. The appraisal district is only responsible for determining the property's value. Section 1131I of the Texas Tax Code states the chief appraiser shall accept a final determination by the executive director as conclusive evidence that the facility, device, or method is used wholly or partly as pollution control property. Both the executive director and the OPIC filed briefs recommending that appeals be denied and the positive use determinations be affirmed. GCC supports the conclusions of the executive director and OPIC. That's all I have to say.
Thank you, sir. Appreciate those comments. Colleagues, any questions for the applicant?
No.
Seeing none, we'll hear next from the executive director. Is there someone?
Good morning, Commissioners, General Counsel.
Good morning.
On behalf of the Executive Director, I'm Don Redmond with the Environmental Law Division. With me is Elizabeth Sartain of the Air Quality Division. The Executive Director recommends that the Commission deny the appeals and affirm the Executive Director's use determinations. Staff reviewed the Tier 1 applications for use determinations for the raw material storage building and exhaust stack used at the applicant's cement manufacturing facility. The Executive Director determined that the raw material storage building and exhaust stack are used wholly for the control of pollution to meet a state rule. Therefore, they are eligible for a 100% positive use determination as an enclosure for particulate suppression under Tier 1 Category A6 and for new stack construction under A-182. After reviewing the contentions of the appraisal district raised in its appeal and reply brief, the Executive Director continues to recommend that the appeals be denied and the use determinations number 23951 and number 23954 be affirmed. Thank you. We are available for questions.
Thank you, Mr. Redmond. I have none. Colleagues, any questions?
No, thank you.
Seeing none, let's hear next from the Office of Public Interest Counsel. Mr. Arthur, are you there?
Yes. Good morning, Chairman. Can you hear me?
Good morning. Loud and clear.
Okay. Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur for the Office of Public Interest Counsel. OPIC supports the ED's positive use determinations for application 23951 concerning the raw material storage building and 23954 concerning the replacement exhaust stack. The record does not indicate that a marketable product arises from use of the property or that the property is not used as described in the Tier 1 table. If ECAD disagrees with this property being included in the Tier 1 table, that issue could be more appropriately addressed through the TCEQ rulemaking process. But for now, the Tier 1 table does include the relevant property, and the appeal is insufficient to overcome the finding which the Commission necessarily made prior to placing this property type in the Tier 1 table. Finally, OPIC notes that a use determination application must be signed and certified. An applicant certified that information submitted is true, accurate, and complete, and property listed in the application is eligible for tax exemption under Texas Tax Code Section 11.31. In conclusion, OPIC concurs with the ED's positive use determination for these properties. Thank you.
Thank you, Mr. Arthur. Colleagues, any questions for Mr. Arthur?
No.
All right, seeing none. I believe the appraisal district here failed to make out a proper appeal. It failed to explain any basis for its appeal until its reply brief, and I think we could deny it on that basis. Alternatively, I would deny it on the merits. I'm satisfied that the evidence shows that the raw material building is consistent with equipment listed under Tier 1 table designation A6. And as for the exhaust stack, I don't see any evidence that the emissions, as it relates to production purposes, couldn't be at ground level, meaning the differential cost of the stack is the entire height of the stack. So even if we were to credit all of the appraisal district's reply brief as the explanation for its appeal, the district failed to meet its burden to show evidence sufficient to overturn the determination. And I'll also note that the district's argument about the tax exemption application process are simply outside our purview. So that's my view of it. Commissioner Lindley, what do you think?
I'm in agreement. I don't have anything to add to that.
Commissioner Janeka?
Likewise. I will not belabor the point and move straight on to a motion that I move that we deny Ector County Appraisal District's appeals and affirm the Executive Director's positive use determinations for application numbers 23951 and 23954.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
May I ask, Megan, is Representative Thompson online or on the phone?
I don't show her on yet.
Okay, we'll go on to 5 then. Item 5 is a petition from Morton Lake Investments LP and West Green Venture LP for the creation of Sun Lake Improvement District. The petitioner should present the matter, followed by any interested persons. Presently, we don't have anyone signed in. The ED and then OPIC. Parties will each have 5 minutes for presentations, and the petitioners may save some time for rebuttal as they bear the burden of proof.
Thank you, Ms. Smith. Is counsel for the petitioner with us?
Yes, sir. This is Zach Petrov with Johnson Petrov. Can you hear me?
Loud and clear. Go ahead, Mr. Petrov.
Great. Thank you. Commissioners, thank you for your time this morning. My name is Zach Petrov with Johnson Petrov. Our firm represents both petitioners in the creation of the proposed Sun Lake Improvement District. This district will be a municipal management district operating pursuant to Chapter 375 of the Texas Local Government Code. The creation process for management districts is a little different from other water districts such as MUDs or WCIDs. Typically, those only have hearings if determined necessary, such as in contested cases. However, management districts are required by Chapter 375 to have a hearing before the commissioners for creation to determine the sufficiency of the petition submitted to the commission, as well as hear the feasibility, necessity, and public benefit of the district, hence the reason we are before you today. No one has contacted our office or raised any concerns regarding the proposed creation of this district. Some information about the district is it's currently proposed to be comprised of approximately 139 acres owned by two separate companies. Both companies are owned and managed by the same person, so effectively the district will have one and the same developer. The district is located or proposed to be located in the west portion of Harris County, located just north of Katy Freeway between Highway 99 and Highway 6. It would be located within the ETJ of the City of Houston and has received consent from the City of Houston for the proposed creation. The development plan currently comprises of approximately 200 single-family homes, 1,200 multifamily units, and 19 to 20 acres of retail. Additionally, recreational and park areas will be located within the district, as well as the district will finance, construct, and assist with maintaining roadways within the district and promote economic development within the district. On water facilities, the district is located within the West Harris County Regional Water Authority, and the authority has added the proposed district to its long-range plan and expected water usage so that the district will maintain compliance with the local Harris-Galveston Subsidence District requirements regarding surface water. The district will obtain water well permits and construct all necessary facilities in compliance with TCEQ regulations and the City of Houston regulations for public water systems. The district did explore the possibility of obtaining water and wastewater services from neighboring water districts. However, due to locations of those facilities of the neighboring water districts, as well as the cost and time in order to extend lines and expand facilities of capacity, it was deemed that was not a feasible option. And so the district will have its own water and wastewater system. The district will construct wastewater improvement system and water treatment system in accordance with TCEQ regulations and the City of Houston design requirements as well. Drainage is always a concern now in Harris County and Houston area after Hurricane Harvey. Currently, South Maid Creek runs through the district, which ultimately discharges into Buffalo Bayou, and the drainage system will be designed in accordance with Harris County flood control requirements and provide retention and detention so as not to increase the peak flow rate of Buffalo Bayou. Currently, there's an approximate 36-acre sand pit that is located within the district and will become part of its drainage and retention plan by creating that sand pit into a large retention facility and connecting that to South Maid Creek. There will be retention pump stations in order to maintain the required retention volume of this 30-acre sand pit converted into a retention facility. This retention facility will also serve a dual purpose as an amenity lake for the residents of the multifamily and single-family units and increase benefits to the residents as part of one of the main centerpiece and attractions to the residents of the district. Ultimately, the proposed district would benefit the public by promoting the health, safety, and welfare of the public through development for the enhancement of the economic health and vitality in the district and the surrounding area, as well as providing recreational areas and enjoyment for the public. The creation of the district is economically feasible based on market projections for the proposed development and necessary for the construction of public facilities in order to promote the development within the district. The petition as submitted to the Commission conforms to the requirements of Chapter 375.022 of the Texas Local Government Code and is sufficient as to all requirements of Chapter 375 of the Texas Local Government Code. Thank you.
Thank you, sir. Colleagues, any questions for Mr. Petrov? Seeing none. Ms. Smith, has anyone signed in to speak on this item?
No one signed in.
Thank you. We'll hear next from the Executive Director.
Good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janeka, General Counsel, and Public Interest Counsel. My name is Hollis Henley, and I'm an attorney with the Environmental Law Division representing the Executive Director. With me is Andrew Painter with the District Section. The Executive Director received a petition from Amar Amancharla as President of Morton Lake Company Incorporated, the sole partner of Morton Lake Investments LP, and is president of Morton Lake Company Incorporated, the sole general partner of West Green Venture LP, for the creation of Sun Lake Improvement District pursuant to Chapter 375 of the Texas Local Government Code. We reviewed the petition and concluded that all applicable requirements have been met. Therefore, the executive director recommends granting the petition for district creation. We are available for any questions you may have. Thank you.
Thank you, Mr. Henley. I have none. Colleagues, any
No
questions?
questions, thanks.
All right, seeing none. Let's hear next from Public Interest Counsel. Good morning, Mr. McWhirter.
Good morning. OPIC agrees with the ED's conclusions that the petition satisfies the applicable statutory and regulatory requirements. We recommend granting the petition for creation of Sun Lake Improvement District and issuance of the order as presented by the Executive Director.
Thank you. Colleagues, I agree. I believe the petition adequately demonstrates that the district is feasible and necessary and would benefit the public, and that it satisfies the other requirements for the creation of this district, including the nomination of five qualified directors. The executive director's order looks appropriate, so I'm ready to move forward on this one.
I am too. I
See
think I'm
nodding
going to
in
make a
agreement.
motion, see if he'll second maybe. I would move that we grant the petition, excuse me, for the creation of Sun Lake Improvement District and issue the executive director's recommended commission order for creating the district and appointing 5 initial directors.
I second that motion.
The motion has been made and seconded. All those in favor say aye. Aye. The motion carries. Ms. Smith, please call the next item.
I think the representative may be on.
Let's check.
So let's call one and see if she's on.
Great.
Item 1 is the application by Rhino Ready Mix LLC for issuance of air quality standard permit for concrete batch plant registration number 162413. The parties have been notified that the commissioners will not take oral argument but may ask questions. Representative Thompson has signed in and would like to address the commission. As a courtesy, members of the legislature and statewide elected officials may address the commission on hearing request matters. However, the commissioners may only consider the draft permit and application, timely hearing requests, responses and replies, timely requests for reconsideration, timely public comment, and the ED's response to comment when making their decisions today.
Representative Thompson, are you with us? Representative Thompson, we can't hear you. I'm not sure if you're there. You might double check your mute button. Let's give her just a moment to try to connect. All right, let's do this. We'll try the representative. Sorry for staff that's playing musical chairs this morning, but we'll try the representative later. We'll take up, I think we're on item 6 now, and we'll come back to number 1. And hopefully Representative Thompson will be able to join us a little later in the agenda.
So item number 6 is the consideration of an order dismissing an agreed order concerning McKinney Smelting Incorporated in Collin County for industrial and hazardous waste violations. The ED will present the item. The respondent, applicant, and other interested individuals and OPIC will follow. Each party will have 5 minutes to present.
Thank you, and good morning. I think Ms. Sprague, are you on the line?
Yes, Chairman. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Courtney Sprague, and I am an attorney in the Litigation Division. With me are Mary Smith of the Remediation Division and Melissa Cordell of the Enforcement Division. Together, we are here today on behalf of the Executive Director. The Executive Director presents for the Commission's consideration an order dismissing an agreed order against McKinney Smelting, Inc., or McKinney Smelting. The subject of the 1998 agreed order is a facility that was once owned by McKinney Smelting in what is now downtown McKinney, Texas. Columbus Fund 2021C LP, or Columbus, is now under contract to purchase the facility from another party and plans to redevelop the property to support residential use. McKinney Smelting remediated the property to commercial industrial standards and satisfied all technical requirements that have become due under the agreed order. The only remaining requirement relates to maintenance of a cover system for contaminated soils for a period of 30 years. This 30-year period began in 2017. Excuse me. By its terms, the agreed order will not terminate until all terms and conditions set forth therein, including outstanding maintenance and monitoring requirements, have been satisfied. Although Columbus shares no responsibility for the contamination at the facility, it has demonstrated over recent months an intention to invest in the remediation of the property to support unrestricted use. Namely, on November 22nd of this year, Columbus applied to remediate the facility under the Voluntary Cleanup Program, or VCP. By statute, a site may not enter the VCP if it is the subject of an existing commission order. In its review of Columbus's application, TCEQ staff determined that the site is otherwise eligible for the VCP and that remediation of the site under the VCP will satisfy the compliance goals of the agreed order. To remove other potential hurdles for redevelopment funding and working with Columbus, EPA recently sought and obtained termination of a 1998 EPA consent decree against the respondent for the same facility. Additionally, on November 17, 2021, a restrictive covenant was recorded in the county property record to sustain the outstanding maintenance and monitoring requirements from the agreed order, which will serve as an enforceable safeguard against any risk the VCP response action will not be completed. Therefore, the ED recommends dismissal of the agreed order to afford Columbus the opportunity to participate in the VCP. Under these limited circumstances, the ED makes this recommendation to remove the only impediment to implementation of a response action at the facility that will, 1, provide for redevelopment in support of the VCP's mission of incentivizing the remediation of eligible contaminated sites in Texas, and 2, will result in remediation to a higher cleanup standard that will allow for unrestricted residential land use. We are here to answer any questions you may have and would like to reserve the remainder of our time for rebuttal if necessary.
Thank you, Ms. Sprague. I have none. Colleagues, any questions?
No questions.
All right, seeing none. Let me check next to see if there's someone with the respondent on the line. Is there anybody with McKinney Smelting wishing to address the commission? Ms. Smith, I don't think anybody was signed in for the respondent.
I don't see anyone signed in on my spreadsheet here.
Okay. Hearing nothing, let's move on to the applicant, Columbus Fund. Is there someone on the line representing the applicant?
Yes, my name is David Whitten. I'm an attorney who represents Columbus. Just for your information, the principals of Columbus are 2 former Dallas Cowboys who, after their playing days, went into real estate many years ago. One of them is Robert Shaw, who played center, and the other is Roger Staubach, the Hall of Fame quarterback. So you've got some really solid people here behind this project. We would like to go ahead and be able to close on the property here next week if we could, get it into the VCP, get it to a residential standard. And what Columbus wants to do is to build between a $60 and $80 million apartments and the amenities that go with that. And this will be right next door to where the city of McKinney is building their new municipal complex. This is kind of juxtaposed to this old scrapyard that has been out there for over 90 years. And so to allow us to be able to get into the voluntary cleanup program, to remediate to residential levels, to put up, a high quality development there in the center of downtown McKinney, we think makes sense for everyone. And we would request that you grant this, and so that we can move forward. I'd be happy to answer any questions.
Thank you, Mr. Witten. I have none. Colleagues, any questions?
No.
I
Seeing
appreciate
none.
the opportunity to look at this. I think this is an interesting, unique circumstance that I expect we may see more of as our state continues to develop and the formerly less urban areas become a little bit more so. And I'm happy to see this opportunity to have this site cleaned to a higher standard. So I appreciate the company's interest.
Thank you, Commissioner Janeka. Ms. Smith, has anyone signed in to speak on this item?
Yes, we have Mark Hauser from the McKinney, City of McKinney.
Good morning, Mr. Hauser. You can go ahead when you're ready, sir.
Good morning, Commissioners. Yes, I'm Mark Hauser. I'm the City Attorney of McKinney. I've been here about 37 years, so I've seen this property in all states of disrepair, and it's now moving in the right direction. The city does own property immediately adjacent. We are in the process of building a municipal complex on the east side of Highway 5, which is the eastern side of McKinney. This project, as Mr. Witten said, is going to enhance opportunities for housing in this part of downtown. It is very much consistent with the vision of the area, and as such, City of McKinney has no objection and is very comfortable with the request.
Great. Thank you, Mr. Hauser. Colleagues, any questions for Mr. Hauser? No. Seeing none, let's hear from Public Interest Counsel next. Mr. McWhorter, what do you think?
OPIC agrees with the executive director. I reviewed the backup materials, and I think the restrictive covenant recorded on November 17th ensures that required safeguards will remain in place, and the public interest will be protected regardless of whether plans for redevelopment proceed. OPIC recommends approval of the proposed order as presented by the executive director.
Thank you, Mr. McWhorter. Colleagues, this dismissal is going to, of course, clear the way for cleanup to a higher standard under the VCP. As Mr. McWhorter pointed out, the state maintains leverage to ensure that the appropriate management of the site, even if the VCP cleanup were to fail, which nobody anticipates, but we're covered either way. So I think this action is going to lead to better environmental and land use outcomes. The City of McKinney, at a minimum, doesn't object. Reading between the lines, I think they probably support this project. EPA has terminated a consent decree to allow the project to move forward, and I think we ought to be pulling in the same direction on this one. Commissioner Lindley.
I'm in agreement. I'd be ready to move forward.
Commissioner Janeka.
Well said. And in light of that, I'll proceed to say I move that we adopt the executive director's proposed order dismissing the Commission's December 1998 agreed order concerning an enforcement action against McKinney Smelting Incorporated, docket number 97-0364-IHW-E.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, I'll ask you to please call the next item, and your choice, it can be 1 or 7.
I'm going to let the Chief Clerk's office check and see if Representative Thompson's on the line.
Good morning, Representative Thompson. Can you hear me?
I can. Can you hear me?
Yes, ma'am, we sure can. Okay, the General Counsel will call the item. One moment. Thank you.
Okay, good morning to everybody.
Good morning.
Good morning. Item number 1 we're returning to is the application by Rhino Ready Mix LLC for issuance of air quality standard permit for concrete batch plant registration number 162413.
And good morning again, Representative Thompson. Thanks for being with us this morning, and I'll just turn it over to you. The floor is yours.
I want to thank you first of all for helping me get on. You know, each time I try to get on one of these, it looks like there's a new technique. But I do appreciate so much you letting me be a part of this discussion this morning. I represent the area where Rhino is attempting, in an area where Rhino is attempting to locate. And I would just like to point out to the committee I know how much hard work goes into the efforts and things that you have to do in listening to all of these various persons who come and make applications and those who challenge those applications. I appreciate all the work that you put in listening and evaluating it. But I also appreciate so much you allowing me to tell you why I oppose this permit being issued. I like to point out that the last protective study that the TCEQ had was about 21 years, to my knowledge, was about, I think, about 21 years ago. And the science states that particulate matter, including crystalline silica, is dangerous to our health. And it causes severe diseases like lung cancer, kidney disease, and other respiratory issues, which may not be experienced until many years later. This is especially concerning given the impact of COVID has had in the Houston area, and then now the variants are having. And what is not only in the Houston area, but even within our state. And a good example of this is Houston 5th Ward and Cashmere Garden, which I live near, have cancer clusters, which was a direct result of soil and groundwater contamination by the Union Pacific Railroad site. The rail yard first ran in 1895, and it hasn't been in operation since 1984. Yet, the contamination and cancer cluster weren't officially determined until 2019. And even then, the company responsible for the environmental mess said the burden of proof rests on the community. The community is helpless, and we are helpless, and that's why we're coming to you to let you know that this is something that, we feel like that we just don't want any more of. I happen to live in an area where we have more than 188 batching plants, and for some reason it always seems to locate and follow the minority community. And I'm not trying to use the race card here. I'm just being factual. The word unjust doesn't even begin to scratch the surface. TCEQ does not monitor air quality or emissions at concrete batching or concrete crushing sites. So there's a serious lack of scientific information about whether or not these plants are meeting emissions requirements. And I hate for these areas to become cancer clusters later down the road when we can change the trajectory now. I understand that TCEQ, I get it. You need to balance economic development. But my constituents who lives near the batching plants already experience health issues related to the concrete batching plants near their home. They have problems. The area, some of the people that are there this morning and who will be testifying this morning, let me tell you, they moved out in a little area, bought 3 to 5 acres of land, green, clean air, and here comes the concrete batching plant. So they are deprived of, number one, being able to have a healthy life and to have the use and enjoyment of their property. They're proud of having a nice little garden without it being dusted up. Who want to raise mustard greens or turnip greens, and then you got to go and dust them off, and then you finally get them washed off, and God knows what you'd be cooking with them. And then it lowers the property value of their property. They decided, well, maybe this house is too big for us, and maybe we need to downsize. This is going to lower the value of their property. And who just want to stand outside for a little while, a little spell, or work in their garden, and walk in like somebody who's dusted you with talcum powder all over? Nobody. So I'm asking you, if you would seriously consider not approving this second concrete plant on Winfield Road, because I don't think that would be, in my opinion, a sound decision, but to send this to SOA for review and to reconsider the approval of this Rhino Ready Mix application. We're not against concrete batching plants. We get it. We know that homes have to be built, roads and highways have to be built, but not at the expense of all of our health all the time. And why should we be always the community? We're always the community where another one, it won't be too much. We have 188 of them now, and it's growing. And we're tired of them. We would like to have a release. We would like to live healthy. We would like to feel like we have a shot at life, a shot at health, a shot at being able to sell our property without it being undervalued, with businesses moving into our property. And Mr. Chairman and members of this committee, I want to thank you for listening to me. I avail myself to questions if you have any. I appreciate so much of you taking the time to have this hearing this morning, and I certainly appreciate you allowing my constituents who will be participating this morning to be heard.
Well, thank you very much, Representative Thompson. We really appreciate you sharing your thoughts with us this morning, and appreciate everything you do. Colleagues, again, we were happy to hear the representative comments this morning, even though it's a little bit of a departure for us on these requests for contested case hearings where we don't take comments. So what I'd like to do now is just dive right into the analysis. And again, for the benefit of the folks who aren't familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requester has met the procedural and substantive requirements to be entitled to a contested case. And assuming that at least one requester has met those requirements, we then consider which issues are appropriate. Again, requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Again, like item 2, we're talking about a concrete batch plant here. So the provision in the Texas Clean Air Act that sets the 440-yard radius for persons who may be considered affected applies here as well. And in this case, we have 4 requesters. One of them, Ms. Ramirez, did not file any comments or make oral comments. So she's failed to meet that procedural requirement, and we are required to deny her request. The remaining 3 requests really turn on this 440-yard limit. And colleagues, I thought the record evidence was unclear, at least it was to me, whether these 3 remaining requesters would be within the 440-yard radius. So I'm very eager to hear your analysis and your thoughts, but my thought is that we could refer this matter to SOA for an effectiveness determination. But what do you think, Commissioner Lindley?
And so that would be for Carol, Christina, and Dyer's Forest Heights Civic Club?
Yes.
Okay. I initially came down on, I didn't find that any of the parties that would be appropriate to grant a hearing. I'm willing to hear out you and Commissioner Janeka, whatever his thoughts are more in a little bit. So I landed on the page of not granting a hearing. But I will say that the record could have been better. It gets real close to the line of a toss-up, but for me, I fell just below I don't quite think a hearing's appropriate, or on that side of the line, I guess is a better way to say it. But yeah, I just think, I don't know how else to say it other than that the record could have been better, and it would have made this call a whole lot easier. I think there was room for improvement in the record. So I'll stop there, and I'd love to hear, we'll punt it.
Yeah. Commissioner Janeka.
Swinging as a tiebreaker. I appreciate both your thoughts, and I think, Chairman, initially I agree with you that the record on the surface level didn't give a very clear answer and does present a bit of a basis to move along to SOA for a determination. I think digging a little bit deeper on my own, I arrived at the plot plan, which lives with the application and gives a better location than the single point indicated on the executive director's map, which I believe was a useful approximation, but agree it may have caused some confusion in what the apparent location of the facility was and what the apparent measured distance is, because this is a very strict line that the legislature has given us. We have no judgment to apply to a 440-line distance, 440-yard distance, and it's one tied to the proposed location of the plant. So I believe it is appropriate to turn to where is the plant proposed and sited, and I don't know that the executive director's map in the record on this application really accurately indicates where that proposed location would be based off of the plot plan. I suspect, based off of that apparent location in the plot plan, that a referral to SOA would ultimately result in what appears to be a further distance than where the ED's map indicates. So I'm in that vein, I think leaning towards Commissioner Lindley's initial inclinations. I think using this matter, this opportunity to provide direction back to the ED staff and the regulatory community in this space, because the legislature has given us such a no judgment call test. 440 yards is pretty strict and clear. I think I would just call to all the parties and stakeholders involved to help us be as precise as possible when describing and locating and talking about the plant, and where, for instance, the analysis presented in OPIC's recommendations on this matter in the record would take a much more expansive view that I don't think entirely comports with the legislative basis of the proposed location of the plant, but does encompass and account for some of the public concerns that we saw, where a later request to change the location could put people on one side of the 440-yard line or another with an opportunity to participate in a contested case hearing process or not, based off of the timing of other parties making decisions that exist in the statute, our rules, and the regulatory space that exists outside of the statute and rules. So using this as an opportunity to signal back to everybody, we need a lot more precision for these permitting actions, for these facilities, so that there's less confusion and entirely, really, the main thrust of my concern is, frankly, that having been given very clear direction from the legislature, we have zero room for discretion, and where there are permits such as this one, where there is another facility that is close enough that it may trigger some other requirements in regards to siting, as it concerns a 500-yard or 550-yard setback from adjacent facilities. That complicates and confounds things. So being as precise as possible really does seem to me to be in our interests. I'm not sure that I hold the view that referring on to SOA would produce a different outcome, but I do see the value in a referral to SOA, if only as a clear indication to all parties. I'll defer you, Chairman and Commissioner Lindley, if doing that by our comments today and rather holding off and not deferring to SOA. I think I could go that way as well. So I don't know if that cleared things up at all, but some of my thoughts.
All right. Well, I certainly agree that there are some legal bright lines here that don't leave us very much discretion. In terms of the facts as they're presented in this case, I'm still a little bit unclear as to how those would stack up, and I would trust SOA to do that job. At the same time, colleagues, I trust your opinion and what you bring to this. So I'm not going to try to persuade you of a view that you don't hold. I know where Commissioner Lindley stands, and I think Commissioner Janeka, you're squarely on top of the fence right now. Is the way that I read that.
I would just make this comment. I would say if we need to be comfortable in our decision, right, whether it's 2-1 or however it comes down. And, if you gentlemen believe that, sending it to SOA for an effectiveness determination will really solidify the record, then I think, you need to do that, right? We all need to be comfortable in our vote. Where I am today, it took a little while to get there because the record could have been better. But where I've come today is, after doing more digging, I'm not there on granting a hearing. But again, I think, we all need to be comfortable with our vote. And so I'm not telling you what to do, but, I know that y'all take the commission's best at heart. And if you think it would be best for the commission to grant a hearing for effectiveness, by all means, you can. And I will just say, and and I'll look to Mary, make sure I don't go outside the bounds here of anything, but, we see these applications a lot. I don't know, every agenda, it feels like, and Texas is growing, and these sites are going to continue to increase. And, I know the industry wants to do the right thing, and by and large, they do. And I know we'll be talking about that industry later on the agenda. I don't think these are the words Representative Thompson used, but I think what she was trying to say at one point in her comments was, that a protectiveness review hadn't been done in a long time, or I think she kind of referenced the science hadn't been looked at in 20 years, I believe is what she said. And I apologize if that's not quite right, but I don't know if it's 20 years. Oh, Mary's starting to give me the look, but should I stop there?
It's been a long.
I think that more general topic is
okay.
Not
well,
been noticed,
yeah,
or not clearly.
Well, what I think, regardless of her comments, let me say that, regardless of what she was saying, is we do need to look at that industry as a whole, and make sure the science behind what the permits that come before us, permits for us today, that we stand behind that. We think that's appropriate. I think it is, but I would encourage the ED, and this might already be happening, that just before there's, I'll be honest, before next session, before we go under sunset review, before the topic is looked at in great detail, we should do our own deep dive into it. And I'll stop there, because that's a little different, but I do think it's important to recognize we need to look at the science on these type of applications, make sure we're good.
Yeah, so we have the issue before us, which has been noticed for us. We have issues related to this, which, you start to get into a gray area about whether they were properly noticed or not. And I'm hearing your concerns. I'm hearing Commissioner Janeka's concerns. And I'll share with you, I've sidebarred with the executive director on some of this already. I intend to continue to do that outside the context of the item that's before us. So I'm very sympathetic. I very much appreciate those concerns that you all have raised, but pulling us back to the item before us, I think we know where the votes on the physical dais line up, and Bobby, I guess I just encourage you. Do you think it's a productive use of state resources to refer this over? Is it necessary? Does it add value, or not quite enough? I'm fine with wherever you land. I'm fine with where Commissioner Lindley lands. We just need to get to a vote on this.
You speak directly to the thrust of, in response to your immediately prior comment and the one you just reiterated. That was entirely the immediate question in my mind. Is it going to be worthwhile for a referral to SOA? Are we properly using the state's resources or not? And it just occurred to me as you were saying that I'm not the SOA ALJ, and far be it from me to make that kind of a determination. So to the extent that process matters, clearly the location of the facility as indicated on the executive director's map does seem to be somewhat in controverted by some of the comments before us in the record. I will be supportive today of moving forward with you to refer this to SOA for the effectiveness determination.
Okay.
And I believe I can make a motion to that effect unless you have a motion prepared to make, and we'll proceed there.
Yeah, well, I have a motion, and let me first say that in the event that SOA determines that there is an affected party, we'll have to refer some issues over too, so they'll be able to take those up at the same time in that event. The issues that I identified were whether air quality will be negatively affected, whether the permit will be protective of the health and safety of the requesters, and whether the applicant has met all of the requirements for a concrete batch plant standard permit. So what I propose I'll do is read those into a motion along with an ADR referral. We can discuss it on the other side, and then when we're ready to take a vote. So Colleagues, I move that we refer the hearing requests of Carol DeJean, Christina Rios, and Dyers Forest Heights Civic Club to SOA for a determination on their effectiveness in accordance with the distance requirement in Texas Health and Safety Code, Section 382.058C. If SOA determines that a requester referred by the Commission satisfies the distance requirement in Texas Health and Safety Code, Section 382.058C, the administrative law judge should proceed with a hearing on the following issues. 1, whether the permit will negatively affect air quality. 2, whether the permit will be protective of the health and safety of the requesters and their families, including sensitive subgroups. And 3, whether the applicant has met the requirements for a concrete batch plant standard permit. I further move that we deny all remaining hearing requests and requests for reconsideration, and that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process. And finally, that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued. So that's my motion. Happy to entertain any discussion or a second at this point.
Thank you, Chairman. I think that captured the issues that I found raised by the requesters in this instance, and I followed that motion as you made it. I second the motion.
Okay, so we have a motion and a second. Any additional comments, conversation, observation?
No, thank you.
That's probably the best answer right now. We've said it quite a bit about this one already.
Exactly.
All right, the motion has been made and seconded. All those in favor say aye. Aye.
Aye.
All those opposed say nay.
Nay.
The motion carries. Ms. Smith, please call the next item.
Item number 7 is the adoption of the 2022 Texas Non-Point Source Management Program. The Executive Director's staff is here to present this item.
Good morning, Mr. Neiman.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Kerry Neiman with the Water Quality Planning Division in the Office of Water. With me today is Faith Hamilton of the Non-Point Source Pollution Program and Stephanie Scogan of the Environmental Law Division. Today, the Executive Director is respectfully requesting approval of the 2022 Texas Non-Point Source Management Program. The draft document was jointly developed by staff of the TCEQ and the Texas State and Soil Water Conservation Board to satisfy requirements of the Clean Water Act. It outlines the strategy in Texas to protect and restore water quality impacted by non-point source pollution. The document incorporates EPA's 8 components of an effective program, establishes long and short-term goals, and provides for the coordination of activities with other partners. A public comment period was held from June 4th to July 6th, 2021, and a public meeting was held on June 21st, 2021. No public comments were submitted during either event. Although no comments were received during the comment period and public meeting, minor grammatical and style changes were made to the document. The Texas State and Soil Water Conservation Board approved the management program on October 4th, 2021. Pending approval from the Commission, the document will be sent to the Governor for approval. Thank you, and we're available to answer any questions you may have at this time.
Thank you, Mr. Neiman. I have none. Colleagues, any questions?
No, thanks for all y'all's great work on this.
All right. Ms. Smith, has anyone signed in to speak?
No one is signed in.
And Mr. McWhirter, what do you think?
OPIC recommends adoption of the 2022 Texas Non-Point Source Management Program as presented by the Executive Director.
Thank you. Colleagues, this is an update without significant changes. It continues to help us manage non-point sources of pollution to our surface waters. It's necessary to maintain federal funding. I'm ready to move forward with adoption.
As am I.
That makes 3 of us.
I will go ahead and, we're done hearing from everyone, right? I will move that we adopt the 2022 Texas Non-Point Source Management Program as recommended by the Executive Director.
Do I hear a second?
I second that. Sorry. Thank you.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, please call the next item.
Item number 8 is the consideration of the nomination and appointment of 7 individuals to the Tax Relief for Pollution Control Property Advisory Committee. The Executive Director's staff is here to present the item.
Good morning. You might check your mute button.
Good morning. Can you hear me?
Loud and clear.
Excellent. Okay. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Elizabeth Sartain with the Air Quality Division. With me is Dawn Redmond with the Environmental Law Division. As described in Section 1131 of the Texas Tax Code, the TCEQ shall establish a permanent advisory committee to advise the Commission regarding the implementation of the Tax Relief for Pollution Control Property Program. The committee consists of 13 members, and 7 of those members' terms expire on December 31st, 2021. The expiring committee positions include 3 industry representatives, 2 appraisal district representatives, 1 taxing unit representative, and 1 independent technical expert. Notice of the vacancies was published in the Texas Register, posted on the TCEQ website, and sent to Gov Delivery subscribers to solicit applications. The submitted applications and the Executive Director's recommendations for appointments to the positions are presented today for your consideration. These appointments will serve a 4-year term. We thank you for your consideration of this matter and are available to answer any questions.
Thank you, Ms. Sartain. I have none. Colleagues, any questions?
I can see Ms. Landwehr in the audience, and I'm tempted to ask her to come up and explain if we address her as Landwehr or Preston. She hasn't had a name change yet, I guess, but she recently got married, so. I guess we'll refer to as Martha Landwehr for this action, but I don't have any questions, and I'd be comfortable adopting the revised list.
It's exciting news. Congratulations. Commissioner Janeka, any questions for Ms. Sartain?
I don't. I was pleased with some of the names on this matter before us. Familiar faces and a few new ones that I think will bring very exciting, competent perspectives to this important advisory committee for our agency. So, very happy to move forward today.
Any questions for Ms. Landwehr?
Or Preston.
Let me cut that off. Ms. Smith, has anyone signed in to speak on this matter?
No one signed in. We can move to OPIC.
Mr. McWhirter, save us.
OPIC supports the Executive Director's recommendations for the appointments of the 7 members of the Tax Relief for Pollution Control Property Advisory Committee. We recommend approval of the resolution as presented by the Executive Director.
Thank you. I do too. This committee, all 13 members, do enormously helpful work on what can often be difficult challenges for the agency. So I want to thank all 13 members. We have 7 nominations who are up. 5 will continue their service, and we have 2 new members. For Mr. Jones and Mr. Ford, who have been members of the committee since its inception and who are rolling off, I want to thank you again. To Ms. Landwehr and Ms. Carter, who will be taking their places. Welcome. We appreciate your willingness to serve. And for re-upping your service, Mr. Adair, Mr. Bieber, Mr. Landrum, Mr. Longley, and Mr. Allred, thank you for your service. That's all I have to say. Commissioner Lindley?
I don't have anything to add. I'll stop.
Commissioner Janeka?
I will proceed and merely make the motion that we adopt the revised proposed resolution appointing the following individuals as members of the Tax Relief for Pollution Control Property Advisory Committee to expire on December 31st, 2025. Bob Adair as a representative from industry, Michelle Carter as a representative from industry, Martha Landwehr as a representative from industry, Roland Bieber as a representative from appraisal districts, Hugh Landrum Jr. as a representative from appraisal districts, Bill Longley as a representative from taxing districts, and Charles Allred as an independent technical expert.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next items.
That will take us to our enforcement docket, which is items 9 through 36. The executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 9 through 36. The total assessed administrative penalties are $394,078, with $57,345 deferred, $63,804 applied for supplemental environmental projects, and $272,929 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No questions. Thank you.
Seeing none. Ms. Smith, has anyone signed in to speak on the enforcement docket?
We have people signed in on items 16, 17, and 21 who have indicated that they don't wish to speak unless the commission has questions, but we don't have anyone asking to address the commission today.
Okay. Appreciate that. And Mr. McWhorter, what do you think?
My office reviewed these items. We recommend approval of the orders as presented by the Executive Director.
Thank you. Colleagues, I agree. I've reviewed these items and I'm ready to move forward with them.
I agree. And it looks like I'm going to make a motion, I think, and I move that we adopt items 9 through 36 as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 37 is the consideration of the monthly enforcement report, and the executive director's staff is here to present the item.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2022 through October. There were 182 effective administrative orders issued, and of those, 28 contained supplemental environmental projects. These orders assessed a total of $2,601,064 in penalties, with a payable amount of $1,495,449. $684,098 are to be paid for supplemental environmental projects. 2,139 notices of violation have been issued through either our field offices or a review of self-reported data in our central office, and 339 enforcement action referrals have been received. There are 1,778 pending administrative orders, with 311 cases that are on the backlog. 196 cases are pending at the Attorney General's office for representation in district court, and 1 judgment has been issued. 2,087 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2020, 2021, and 2022. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No, thank you.
Commissioner Janeka?
Thank you for the report.
And Ms. Smith, has anyone signed in?
No one is registered on this one.
And Mr. McWhorter, what do you think?
I appreciate the report. I don't have any questions.
Thank you. I do too. Thank you, Ms. Cordell, to you and your team for the report. No action is necessary on this item, so Ms. Smith, I'll ask you to call the next item.
We will be taking up 38 out of order, so we will go to item 39. Next, that is the consideration of the publication of and hearing on the proposed amendment to 30 Texas Administrative Code, Chapters 331, regarding underground injection control to implement portions of HB 1284. The Executive Director's staff is here to present the item.
Thank you, Ms. Smith, and I believe Mr. Hanna may be on the line.
Yes, good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Dan Hanna with the Radioactive Materials Division. With me is Maddie Esturez with the Environmental Law Division and Carol Dye with the Radioactive Materials Division. The proposed rulemaking would implement House Bill 1284 from the 87th Legislature 2021 regular session, repealing TCEQ jurisdiction over the injection of carbon dioxide produced by a clean coal project into a zone that is below the base of usable quality water and that is not productive of oil, gas, or geothermal resources. The proposed rulemaking would amend Chapter 331, Underground Injection Control, by removing subsection 331.11d. A virtual public hearing on this proposal is scheduled for January 25th, 2022. Staff respectfully recommends approval to propose the publication of and hearing on Chapter 331, Underground Injection Control. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you for your consideration. We are available to answer any questions.
Thank you, Mr. Hanna. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka.
Great to hear some familiar voices, but no questions for me. Thanks.
Ms. Smith, has anyone signed in?
No one's registered on this one.
Thank you. And Mr. McWhirter, what do you think?
OPIC recommends approval for publication of and hearing on the proposed rulemaking to implement HB 1284 as presented by the Executive Director.
Thank you. Colleagues, this is really a straightforward bit of legislative implementation rulemaking to transfer jurisdiction of these wells to the sole direction of the Railroad Commission. I don't see any reason why we should not put it out for comment.
I agree.
I think we're ready for a motion.
Likewise. I wish our colleagues, I'll only add that I wish our colleagues at the Railroad Commission all the best and good wishes on their quest for delegation in this space. I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 331, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item 40 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 311, Watershed Protection, related to best management practices for sand mining facilities in the San Jacinto River watershed. The Executive Director's staff is here to present the item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Michaela Coleman with the Water Quality Division. With me today are Erica Crespo and Rebecca Villalba with the Water Quality Division and Michael Parr with the Environmental Law Division. The Commission received rulemaking petitions from the Lake Houston Area Grassroots Flood Prevention Initiative and the Texas Aggregates and Concrete Association in June 2020. These petitions were approved at the August 12, 2020 agenda, and the Commission directed the Executive Director to initiate rulemaking with stakeholder input. The proposed rulemaking adds new sections in the Watershed Protection Rules, Chapter 311 of Title 30 of the Texas Administrative Code, and establishes requirements for sand mining facilities in the San Jacinto River watershed. The proposed new sections 311.101, 311.102, and 311.103 include the following. Define the San Jacinto River watershed, which identifies the scope of the proposed watershed protection rules. Require the Executive Director to develop a guidance document of best management practices, or BMPs, for sand mining facilities in the San Jacinto River watershed. Require sand mining facilities in the area to develop and implement BMPs from the guidance document of BMPs developed by the Executive Director. Require sand mining facilities in the area prior to commencing or continuing operations to prepare and implement a mine plan signed and certified by a Texas licensed professional engineer or geoscientist. The plan must be kept current and include the elements described in the BMP's guidance document. Require sand mining facilities in this area prior to terminating operations at the site or portions of the site to submit to the Executive Director a final stabilization report signed and certified by a Texas licensed professional engineer or geoscientist. The report must include the elements described in the BMP's guidance document. Require sand mining facilities in this area to implement and complete the final stabilization report prior to terminating authorizations as required by 30 Texas Administrative Code Chapters 205 and 305, and establish a 180-day compliance period for sand mining facility operators registered as an aggregate production operation with the Commission on the effective date of this rule to implement certain portions of the rule related to BMPs and the mine plan. The proposed rulemaking was published in the Texas Register on June 25, 2021. A public hearing was held on July 22, 2021, and the comment period closed on July 27, 2021. Public comments were received and responses were developed that included revisions to the proposed rule. The responses to public comments are included in the backup material before you today. In conjunction with the rulemaking, the Executive Director developed the BMP's guidance document that supports the proposed rule, considering input from the petitioners and stakeholder involvement. Staff respectfully requests adoption of the proposed rule in response to comments. Additionally, staff requests authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Coleman. I have none. Commissioner Lindley, any questions?
No, thank you.
Commissioner Janeka. Has anyone signed in, Ms. Smith?
We do have 2 people signed in, and the first who would like to address the commission, the first is Mr. William Dupre.
Good morning, Mr. Dupre.
Yes, thank you very much. Can you hear me?
Loud and clear, sir.
Okay, great. Very good. I'm a professor emeritus at the University of Houston Department of Earth Science, and I've been doing research on the San Jacinto River for the last 30 years. I want to thank the commission and the people that have been working on this proposal. It is an excellent approach to dealing with a serious problem. But I do have a couple of comments that I would like to make. And one of them is, at the very beginning, the intent was to define the San Jacinto River watershed with respect to those areas that the bill applies to. And the wording is the San Jacinto River watershed. Those portions of the San Jacinto watershed that include the watersheds of the following in their tributaries. And then there's a list of 7 watersheds. Now, the problem comes with respect to the question of what do those portions mean. There were comments earlier said there was a conflict between the geographic scope and a graphic which basically showed the map of the area. There is a map that says the San Jacinto River shed, and it basically encompasses the entire San Jacinto watershed north of Lake Houston. The problem is it does not, it includes areas which are not specifically listed as portions of the watershed. And I mean, be a little more specific. There was a question in one of the comments that the area upstream of Lake Conroe was not included in the list, nor was the area Loose Bayou. The response was that it is included because those are tributaries as listed. The fact is, if you read the description, the West Fork of the San Jacinto is defined as the area from the dam at Lake Conroe to Lake Houston. It very specifically excludes the area north of, or rather upstream of Lake Conroe, and that's an area of something like 450 square miles. The other issue is Loose Bayou. Loose Bayou is assumed to be a tributary of East Fork of the San Jacinto. But in fact, if you look at any map of the bayous and watersheds of the San Jacinto watershed, subbasins in essence, be it TCEQ maps for their watershed protection plans, or the San Jacinto River Authority watersheds, or the Harris County Flood Control, they all recognize that Luce Valley is not part of the East Texas water, or the East Fork of the San Jacinto. They are separate watersheds. They have separate numbers. And so, to summarize, a strict reading of the words in the definition of the San Jacinto Rivershed excludes Luce Bayou and excludes the area of Lake Houston. This could be very easily modified, but as it is, there is an extreme ambiguity and actually an ease of misinterpreting, I think, what is the intent of the legislation. And I would encourage a rewriting of that section to make it more clear that the area in the map includes all of the areas and not just the ones that are specifically flagged by words. The last question I have is that I'm concerned about the the mine plans and the exceptions or alternative BMPs not being previewed by the ED, but rather simply being kept on site for review. Can I, as an individual, go on site and look at those BMPs and those modified plans, or is that something that can only be done by an official? I appreciate your time, your effort. If you have any questions, I'll be glad to try to address them. Thank you.
Well, thank you very much, Mr. Dupre. I appreciate your comments and the attention that you've given to this rulemaking package. Colleagues, I think I'll ask the executive director staff to respond to those 2 points that Mr. Dupre raises. One about the availability of BMPs on file with a regulated entity that are not submitted to the agency, and the other one concerning this apparent disconnect between the map and the list of water segments that fall within the scope of the rule.
Chairman, if I might butt in right now to add a slight elaboration to your question. First question about the availability to the public, copy of the mine plan. Could staff merely speak to how and where any version control or the mine plan gets captured or acknowledged in the application of the records? Does any copy or a version, how do we address the concern that the regulated entities being responsible for these plans, inspectors may have seen them and be able to certify what was in them or not? If there is a very controversial neighbor that is convinced that those plans have been changed the minute the inspector stepped off, what backstops does our agency have in terms of our process to be able to help ensure the public with that boogeyman? There's a question very close to that availability of those mine plans that was in mind.
Thank you, Commissioner Ginecka. And Ms. Coleman, we'll turn that back to you or anybody else on your crew who wants to answer.
Thank you. This is Michaela Coleman with the Water Quality Division. I'll first address the questions and comments regarding the mine plan documentation. The rule requires this documentation to be maintained on site because this is consistent with the existing regulatory scheme for stormwater. It's required to be maintained on site. Additionally, because this document is being signed and certified by a licensed Texas professional engineer or geoscientist, the ED has an additional safety net for that certification as far as when the public would have the opportunity to view these documents. Because they are maintained on site, the general public would not have the authority to show up and request this document. However, if ED staff were to visit the site and maintain or receive copies of this documentation, it would be saved in the record for the public to view. And then secondly, to address comments related to the watershed definition. This watershed definition was initially proposed by the petitioners, and through stakeholder involvement, the ED developed a map to demonstrate what the text is representing, and that's what was included in this rule package. And so the watersheds were developed using U.S. Geological Survey existing watershed boundaries to encompass the text of the watershed definition. And that is what has been included in this final rule package. Thank you.
Okay, so Mr. Dupre's concerns, though, about the disconnect, I'm wondering, are we going to confuse the regulated community about whether they're in or not in? And I'm not sure that we've quite answered that question. I mean, I guess at a minimum, I think the regulated community should expect that if they're anywhere on the map, even if not listed in the expressly in the list of terms, that they're liable to have a plan. And if they have any questions about whether they're in or outside the scope of this rule, they're better off conferring with the agency before an investigator shows up.
Chairman, this is Michael Parr, the Environmental Law Division. Can I?
Yeah, go ahead.
Just a second.
Yeah, go ahead, Mr. Parr. Thank you.
While we were working on crafting the watershed definition, we were working closely with TACA, and TACA had expressed us they plan to have, not guidance, but to inform their members of where the, what the watershed encompasses and, whether you're in or out. And with regards to the scope of the watershed, we were given direction to, address sand mining in a certain part of the river. So the reason that the scope isn't what everybody likes, because it can never be, can't please everyone. But the reason the scope isn't as large is because we had narrow directions to address this particular issue in the watershed. Does that make sense?
I think so, but let me try to pin you down. Should the regulated community rely on the map?
Yes. The map was intended to, everybody inside the shaded area would be included.
Okay.
Chair.
Yeah, is
Chairman,
that Ms. Coleman? Go ahead.
Mr. Chairman, this is Rebecca Villalba with the Water Quality Division. Can you hear me?
I can. Go ahead, Ms. Villalba.
Okay. Great. Thank you. Yes, and I would just like to add that the map will be available on the website so people can see it. And while it may not be as specific, as we would like it in terms of identifying everybody there, we are working together with Office of Enforcement and Compliance, the regional offices in Region 13 and 9 to help identify exactly the universe. We initially identified a potential of maximum 114 facilities. So we are narrowing that down so that we can definitely understand who is within that area, and then working together, coordinating with small business local government assistance, we will notify those entities as well. But yes, the best thing, and we're going to put it on the website, is that if anybody is unsure of whether they fit within that area, they can definitely contact us, and we'll be happy to confirm that information.
Okay. Thank you, Ms. Villalba. I appreciate those comments. Colleagues, any questions or comments at this point? So Ms. Smith, did you have? Right. Let's go ahead and hear from the next interested person, and then we can loop back to these issues to the extent we need to do that.
The second person that we have signed in is Mr. William McCabe.
Good morning, Mr. McCabe.
Good morning. Can you hear me okay?
I can, sir. Go ahead.
Okay. Good morning, Commissioners Neerman, Lindley, and Ginecca, General Counsel, and Public Interest Counsel. My name is Bill McCabe, and I represent the Lake Houston Area Grassroots Flood Prevention Initiative, one of the original petitioners in this proposed rulemaking. First, I would like to thank TCEQ for working closely with us to develop this BMP rules document. Ms. Coleman gave an excellent summary early on, and we worked with her and Rebecca and Michael throughout this endeavor. I'd also like to thank TACA for their input. The rule, coupled with the guidance document, represents a major step forward in controlling sand mining pollution. The new rule will benefit industry as well as the public in the San Jacinto watershed. That said, there is a pressing issue this commission must also address, and that is transparency. The rule states that a mine plan must be developed and maintained on site. It also states that if a BMP is infeasible, detailed supporting documentation shall be maintained on site. Good operators will maintain such records. Problem operators may not. Merely maintaining this documentation on site to be produced in the event of a catastrophic event is not very comforting to those living and breathing downstream from a mine. If we find out after a major flood event that the rule is not being followed, it does us no good. Additionally, if the next flood destroys on-site records, there will be no way to verify whether the rules were being followed, and this whole effort will have been wasted. Transparency is the key to both enforcement and public safety. There are various ways to provide transparency. The first I would suggest is that TCEQ should require documentation be kept online as well as on site, just as the TCEQ does now for water testing records. These records could be kept on a secure website accessible only by TCEQ. Having the documentation online will also make periodic checks by TCEQ easier and less expensive. It would likewise protect documents in the case of flooding. A second option may be to set up a 5-person committee consisting of one TACA representative, one TCEQ representative, and 3 public members appointed by the governor. This committee would monitor compliance and report quarterly to the public on the new BMPs. This group could validate compliance, diagnose effectiveness, and recommend improvements. Thank you for your consideration of our requests.
Well, thank you.
I'd be happy to answer any questions.
Thank you, Mr. McCabe. Let me pause there. Colleagues, any questions or comments for either Mr. McCabe or Mr. Dupree?
No, thank you.
Okay. Well, to try to summarize, I think I've heard 3 issues. There's a question about whether the scope is adequately defined and whether there might be a disconnect between the map and the water segments as listed. Mr. Dupree and Mr. McCabe also both raised the issue about transparency of the documents, the plan documents, and Mr. McCabe also raised the specter of the loss of those documents in the event of a flood if they're only kept in hard copy on the site, the mine site itself. Yeah, I think all of these are reasonable concerns, and at this point, I don't see that these need to stand in the way of our adoption of the rule. I think we're ahead of the game if we move forward with adoption and take these issues up separately to decide whether they're whether we require further changes, maybe a rule amendment or some additional guidance to help shore these up. But and in terms of my personal view and position on it, I think all 3 of them, I don't have I haven't formed an opinion or a well-informed opinion on any of them. Certainly if we discover that any of them are a problem, we can move them up the list. If there's a For example, a problem with enforcement efforts tied back to our description of the scope of the rule. We can certainly, if we haven't already, come back and amend the rule to tighten that up. So I'd say let's not let the perfect be the enemy of the good. Let's move forward with this and then take up those issues kind of as the next order of business and as need dictates. So that is my view. I also want to share the thanks that's been passed around to the stakeholders, to the regulated entities and the citizens who asked for this rulemaking in the first instance and who have been active participants in developing the rule. I think clearly it's going to lead to better environmental outcomes. So we really appreciate their input, their continued input. And with that, I think I'm ready to move forward.
Yeah. I don't know. Did we hear from the rule petitioner or do we?
OPIC.
OPIC.
We haven't heard from OPIC.
Oh, okay. I was thinking there was someone, yeah.
Anything else before we hear from Mr. McWhorter?
No, I was going to use your quote of let's not let perfect get in the way of good. I think it's time to move forward with adoption with this because it's, this is a great example of stakeholder involvement and how the stakeholder process can work. And so I'm grateful for everyone that's been involved, both on the ED side, all the petitioners. But we'll wait and hear what they have to say. But I would be in favor of adopting the amendments that are before us today.
Commissioner Janetka, why don't we let Mr. McWhorter chime in next, and then I'll gather up any additional thoughts. And we'll go from there. Mr. McWhorter, what do you think?
OPIC recommends adoption of new subchapter J of the Commission's Chapter 311 rules to establish best management practice guidance for sand mining operations in the San Jacinto River Basin as presented by the Executive Director.
Thank you. Me too. Commissioner Janetka, what are your thoughts?
Well said. I don't know that I can improve on either of your prior comments other than just to note that I share your thanks of the two, all the stakeholders involved in here, and I think having the two rule petitions that aligned almost entirely with some nuance in highlighting the different interests and the priorities of those stakeholders are really well reflected both in the product that the Executive Director presented forward, the improvements between proposal and adoption, and I'm very pleased to see that the thrust of the comments and the calls for greater backstops or assurances to the public, I think are really answered in spirit in the idea of this mine plan requirement, moving it forward from the closure stabilization plan at the end to a early snapshot and an end snapshot. And just to circle back to the question I asked, heard from ED staff on, I'm very satisfied hearing that the certification step, the PEPG requirement, and independent certification, where and however that may be appropriate, I think are very compelling backstops in my mind to give us a very real assurance to the public without justifying the regulatory cost of creating another state website where we're having to maintain digital copies of things and putting it online, and it's, oh, by the way, it has to be accessible and reformatted for the state requirements for how to publish things. The prospect of let's move everything up to be immediately available sounds wonderful on its face, but I'm not sure that we can justify the cost juxtaposed against the potential for a problem where if God forbid a facility should lose their actual paper plans, I think having that requirement that there's another professional somewhere in our state who would have saved a copy for their records, and this company would they would have every interest in being able to produce the original record. So I'm not concerned that we have any big open glaring holes right now. I'm eager to continue to hear from the stakeholders as we implement this, move into the actual specifics of best management practices, what those look like in practice, and continue to evolve with this conversation. So far more than I needed to say on that. I'll wrap up and just say I move that we adopt the amendments to 30 Texas Administrative Code Chapter 311 as recommended by the Executive Director. Okay, thanks.
I'll second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 38 is the consideration of the publication of and hearing on new Section 60.4 of 30 Texas Administrative Code, Chapter 60, regarding compliance history. The Executive Director staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski, also of the Enforcement Division, and Jess Robinson with the Litigation Division. For your consideration today is a rulemaking request to propose new Section 60.4 to 30 Texas Administrative Code Chapter 60 compliance history. The rule would allow for the Executive Director to designate and reclassify the compliance history classification for a site involved in an emergency event that causes or results in exigent circumstances. Recent events over the last several years have caused significant impacts to the public and the environment, which has prompted scrutiny of the environmental compliance histories for the companies involved in the events. Currently, Chapter 60 of our rules directs compliance history classifications to be based on certain information from the previous 5 years, and sites subject to the program are classified every year as unsatisfactory, satisfactory, high performers, or as unclassified if there is no compliance information about the site. Because classifications are based only on certain information from the previous 5 years, emergency events are not captured or reflected on site compliance histories or classifications until after they result in an administrative order or civil judgment to resolve a related enforcement action, and this component is accounted for and it is in a regularly scheduled annual classification. Multiple months or years or even years can pass before an administrative order is finalized or a civil judgment is reached, and in the interim, the subject site's compliance history classification and underlying data may not account for the occurrence of an emergency event. The Executive Director would like the ability to designate and potentially reclassify a site's compliance history classification so that it reflects the occurrence of an emergency event in a more prompt fashion. Through this Section 60.4, the designation and reclassification would occur outside of the annual classification process and in a manner differently than currently allowed in Chapter 60. This proposed rule lays out an overall two-step process to authorize the Executive Director to designate a site's concurrent compliance history classification as under review if the Executive Director determines that exigent circumstances exist due to a significant emergency event at the site, and to later, if warranted, reclassify the site's compliance history to suspended. The proposed rule identifies the criteria to determine if exigent circumstances exist for the Executive Director to designate a site's compliance history classification as under review. The event must meet all 3 criteria for its resulting circumstances to qualify as exigent under the rule. First, the circumstances must include significant disruption to one or more local communities of people. Second, the circumstances must include significant commitment of emergency response resources by a federal or state governmental authority to address an actual, unauthorized release of pollutants, contaminants, or other materials regulated by the TCEQ. Third, the circumstances must include at least one of several occurrences reflecting urgent governmental response or impacts to human health. These include qualifying emergency orders, temporary restraining orders, temporary injunctions, or an actual unauthorized release of pollutants, contaminants, or other materials regulated by the agency that causes evacuation, sheltering in place, or directly attributable injury or death. Under the proposed rule, the Executive Director may determine that it is appropriate to escalate after designating a site's compliance history classification as under review. This entails the Executive Director then issuing a notice of decision to reclassify the site's classification to suspended, which immediately begins a type of scrutiny for permit application and starts a procedure that could end with the site being reclassified to suspended. The scrutiny for pertinent applications would involve agency review of the applications in light of the emergency event, which enables the agency to address whether the event should impact the agency's approval with certain conditions, or denial of the application. The proposed rule includes a process for the site owner or operator to have the opportunity to demonstrate to the Executive Director that reclassification of the site to suspended is not warranted. The rule also includes a process for the owner or operator to appeal the Executive Director's decision to the Commission for review prior to the actual reclassification to suspended. If the site's compliance history classification is actually reclassified to suspended, the impacts of the reclassification would include the continued evaluation of a site's permitting applications, and the site would be treated as an unsatisfactory performer as identified in Section 60.3, Use of Compliance History. These impacts would continue for the duration of the reclassification. The reclassification of a site to suspended would be effective for at least 1 year from the effective date of reclassification and thereafter until the earlier of 3 conditions. Those conditions are proposed to be: first, when the executive director decides that the reclassification is no longer warranted, this decision would be based on whether the exigent circumstances have been resolved, the cause of the event has been identified, and corrective actions have been implemented so as to appropriately reduce or eliminate the likelihood that the same or a similar event would reoccur. Excuse me. Second, when an enforcement action arising from the emergency event is either A, resolved and it resulted in a component accounted for in the site's standard compliance history classification, or B, such a case by or on behalf of the TCQ is neither pending nor anticipated. Third, and ultimately, the reclassification would end 3 years after the effective date of the reclassification. A virtual public hearing will be offered on this proposal on January 27th, 2022. Staff respectfully recommends approval to propose the publication of and hearing on the proposed new Section 60.4 of 30 TAC Chapter 60 Compliance History. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions, thanks.
Commissioner Janeka? None. Ms. Smith, has anyone signed in to speak?
We have people signed in, but they indicated that they don't wish to speak, so their presence will be noted for the record.
Thank you. And Mr. McWhirter, what are your thoughts?
OPIC supports moving forward with the proposed rulemaking. We agree with the concept of allowing flexibility in considering the compliance history of an applicant in light of exigent circumstances and emergencies at an applicant's site. OPIC recommends publication of and hearing on proposed new Section 60.4 as presented by the Executive Director.
Thank you, colleagues. I think that's right. I think the spate of events that Ms. Cordell referenced, I think there's a broad consensus that they revealed a shortcoming in our compliance history rules. I think there's also a broad consensus that we need to correct that. That's what this rulemaking is about. And I think there's even broad consensus about the basic, kind of direction and architecture of the rule that's been pulled together. I do think it's going to require some additional work. I think this is going to be a really active rulemaking process, so we look forward to that. I want to thank staff for all their great work on this so far. I'm ready to move forward with adoption. Your thoughts, Commissioner Lindley?
I would ditto everything. I think staff has done a great job getting where we are today, what's in front of us today. I know it's been a long process. I do think we'll get a lot of comments. I think they'll be beneficial. I think it'll be good to hear from folks on this, and we'll see what adoption looks like. But I'm very comfortable moving forward with today with the publication. Excuse me.
Thank you, Commissioner Janeka.
I don't think I have anything to add to alter what each of y'all said. I think I'm interested and eager to see where the comments and specific feedback or outstanding concerns will be indicated back to us. I think this is a great draft considering many of the concepts we discussed on some previous occasions, and I'm pleased with the apparent thought that really has gone into this, and I have no doubts that the conversation is continuing, and I'm sure that ED staff will be eager to see those comments as well in terms of trying to miss any, oh yeah, that's right, and this is that refining stage, so please public, don't miss the opportunity, and I hope to have this conversation unfold. Thank you.
Thank you. I think we're ready for a motion.
I will, go ahead. I'll do it real quick, I guess. I will move that we approve the publication of and hearing on new 30 Texas Administrative Code Section 60.4 as recommended by the Executive Director.
Second motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
The next item, number 42, is our public comment session, where the commission will receive comments from the public on matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permitting matters or other contested cases. These are subject to an ex parte prohibition found in Texas Government Code Section 2001.061. In the interest of time, speakers will be limited to 3 minutes with a total time for public comment limited to 1 hour. Please note that the Commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual response and recitation of existing policy. We have one person signed in, Ms. Lydia Ponce, but it appears that she has dropped off. The webinar is no longer on, but we'll open up the line for a moment to give people a chance.
Is there anyone on the line wishing to address the commission during the public comment session? Hearing none. Is Ms. Ponce on the, well, no, she would have piped up, right?
Yeah,
She's not.
she's not on the line any longer.
How about this? We're going to go into executive session a little bit. I think I'm going to be ready for a break before executive session. We could take a short recess now and give Ms. Ponce another.
I believe she notified the chief clerk that she was dropping off to attend another meeting. And
Oh,
not
she
be
was
able to come
intentionally
back
dropping
on. Yeah.
off. She's not trying to get back on. Okay.
Right.
Well, in that event, I think gone on item 42. I don't think we have anybody wishing to address the commission. So, Ms. Smith, let's call the next items.
Items 43 through 46 are for closed session. The commission will meet in closed session in room 211S in this building at 11:35.
I think 11:30.
11:30, and we'll also partially meet virtually with Commissioner Chineka.
And then after executive session, someone will return here to gavel us out. And with that, the time is 11:27, and we are in recess.
The commission met in room 211S in Building E for closed session from 11:31 to 12:02 on item numbers 44 through 46, as posted in notice pursuant to Texas Government Code, Section 551.074. No action was taken. The agenda stands adjourned. The time is 12:05.